Hey everyone, Harry here. You may recall that a judge in San Francisco, William Alsup, along with a judge in Maryland, entered an order requiring the administration to stop firing their probationary employees and to reinstate the ones that they have fired. And that was just about the law of civil service protection, which gives certain, if not great, protections to probationary employees. More or less, people have been there for about a year until they graduate to permanent status. And that can be, by the way, people who've been in the federal government for many years, but it's when they're in that new job. Okay, that case in San Francisco, the United States has been very aggressive about appealing. And they appealed it to the Ninth Circuit, and before the Ninth Circuit has done anything, but the appeal was lodged there, so that gives them the channel. They've moved the Supreme Court for an order staying what the district court did below. That's where things stood as of yesterday. Now we have a fairly big twist, which is the district court has revised its previous opinion to recognize another claim of standing. Standing is what this both skirmishes are about. So in the first instance, there were two kinds of plaintiffs in front of Judge Alsup. They were both organizations, and one said, we represent the employees here, and that's, we're being harmed because of the harm to the employees. That's the theory that Alsup rejected initially and has now reversed. I'll come back to it in a moment. The other was organizations that their claim of standing was they use federal facilities, same as everybody else. And while probationary employees have been gotten the sack, they are not able to enjoy them. And federal parks are closed and post offices are hampered and the like. It's that claim of standing that the United States has charged into the Supreme Court, saying, reverse them, there's no standing there. Go tell the district court that they shouldn't have entertained the claim on the merits, or even the preliminary claim on the merits, to freeze the merits and consider them because there wasn't standing. Alsup now has added another prong of standing. He has said those organizations, in fact, do have standing. They are injured. We knew that because, among other things, they lose members' dues, and they're able to state a claim of injury. The problem that initially persuaded Alsup was that the law that provides all these protections to employees, merit systems protection, etc., within the executive branch, precludes the courts from getting involved until you've, what they say, exhausted administrative remedies. You have to do that first. And until then, the courts don't have jurisdiction, except for certain claims that Alsup has decided that's what's involved here. You couldn't just go and bring the kind of claim to a federal court that you could and therefore must bring to the Merit Systems Protection Board, like I was doing a good job, or they didn't give me notice and opportunity. But the kinds of claims they're making here go to the basic authority of OPM, and that's the sort of thing that isn't covered by, in fact, there's no way even to bring it under the Merit Systems Protection Board. You come and say, they messed with me and it wasn't fair, but not these broader issues of power for OPM. And what Alsup holds, and there's case law that's solid there, assuming that the higher courts agree with its application by Alsup. But what Alsup holds is this is such a case where the plaintiffs, that second group of organizations that I previously said have no standing, in fact, on reflection and further briefing, they are bringing claims of a sort that individual fired probationary employees couldn't bring. Moreover, if they can't bring it, it's not clear. It looks as if it can't be brought altogether. So while this concerns generally the fate of probationary employees, it doesn't concern generally the whole Merit Systems Protection Board system of first executive branch review followed by limited federal court review. That's because it's going to broader issues of authority and constitutional adherence by the OPM in particular. And that's, if Alsup says they got to have standing because otherwise there will be no way for these claims to be heard. And the basic command in that, district courts must exercise jurisdiction if it's in front of them is what controls. He cites Gorsuch, drops a little footnote there thinking, this is probably going to the Supreme Court. But that's what controls. Okay, so what happens now? I think it's just sort of two separate things. So they're in front of the court, the Supreme Court, on that first theory. Now, there could be a logical, but someone would have to make a motion. Judge, Your Honors, you're justices of the Supreme Court. There's now been another holding in the district court. Let's try to consolidate them and make that part of the emergency relief. But if they don't, or if the court, has in essence already decided it and is about to issue its ruling, then it seems to me, at best, it can dissolve that first injunction by the district court if it says there was no standing for one group of plaintiffs. But we now have a whole new group, and that doesn't affect that opinion. So I think they would just be starting at square one with the government, and they could, again, fight through the thicket, try to get to the Supreme Court, challenge a whole separate argument about standing and why the sorts of claims the certain organizations are bringing on behalf of employees are actually fine standing-wise. Now, Alsup's decision, it's a very kind of forthright one. It goes against three other courts, and it goes against what he himself said like a week ago. But, he puts it out there. Look, but here's the reason. Here's the briefing and the new principle that's been proffered to me. These are not merit systems protection stuff, but rather broader constitutional claims. And they won't have a chance to be brought if we don't do it here. So there you go. It looks on paper like, what? He didn't do it, and now he did, but only after the Supreme Court took the other one. But I think he's sort of, justified it on the papers. And it just now stands as a whole new theory for the U.S. to do its best, and it certainly will, to attack and try to beat back. Talk to you later.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.